I'm paying attention to the time, and that way I can give you your warning as you come up on your 15 minutes if you choose to reserve 5. Other than that, we're ready to go whenever you are. Our first case is Perry versus Turner.
Morning, Your Honor. Jesse Butler here on behalf of the appellant Richard Perry, who's here with me in the courtroom. We'd like to reserve 5 minutes for rebuttal.
All right.
Thank you. May it please the court. The trial court here applied 2 equitable defenses that worked in equity in their result. The trial court found that over a course of about a decade that there was a romantic relationship between Mr. Perry and Ms. Turner. And during that time, they both agreed and participated in an unorthodox and probably ill-advised plan by which Mr. Perry placed essentially the bulk of his assets in Ms. Turner's name, including the primary residence, which the court found he paid the mortgage on. He put almost $800,000 in home improvements into, and it was the place that both Mr. Perry and Ms. Turner believed that they would live for the rest of their lives. He also purchased 8 rental properties, and he was the source of the funds for those rental properties that were placed into a separate entity formed called DNR Spaces. The court found that Mr. Perry's testimony was essentially the more accurate testimony. Ms. Turner called herself as a witness in her case and was the only witness in her case. And in a fairly detailed judgment, the court rejected her testimony, said that the testimony that Mr. Perry did all this as gifts over this decade was not borne out by the record. These were not gifts. That this was part of a plan that they both engaged in to try to keep assets.
Well, isn't that the key? They both engaged in it.
Yes,
And under the imperi delicto doctrine, isn't that sort of the beginning and the end?
it is not, Your
Why
Honor.
not?
2 reasons. One, there has to be illegality. The case.
Why? I read your cases on that, and I'm not sure that I agree with you on that. And what I want to focus you on is there's a body of law that speaks in more general terms than you cited in your briefs that recognizes the applicability of this doctrine where the conduct has the effect of violating public policy. And here, the avoidance of child support obligation unquestionably is against public policy. So I'd like to hear you speak to that and assume for a minute that I don't agree with you on a straight up finding of illegality, because I don't think Stockholm said that, and I don't think any of the cases you cited actually do as much as you want them to do. So I'd like you to talk to the public policy.
Yes, Judge. A couple of points on that. First of all, we do believe that the imperi delicto argument, when you look at the cases that we've cited, as well as the cases that the appellate cites, does require illegality. There are some cases that talk more generally talking
Give
about
me your best case for illegality, because I'm not seeing it.
One moment, Your Honor, and I'll cite that in the course of my argument.
Okay,
But
I want that before you sit down.
yes, Your Honor. With regard to the more general cases, I acknowledge there are cases that talk about wrongful conduct. But when you look at the actual cases themselves, it's more than an allegation of wrongful conduct. There's actual evidence that something happened that defrauded somebody. And usually that it's something illegal.
He evaded the ex-wife, there's a child.
There's no evidence of that, Your Honor. That there was argument, there was repeated argument that happened. There is no evidence in the record that he ever evaded a child support.
That he's selling in 2021. That's evidence of the existence of those proceedings, isn't it?
That there was an affidavit signed shortly before trial, well after all of these transfers took place, years after all these transfers took place.
Right, but if you want us to view this record as being barren, any evidence concerning the child support enforcement litigation,
So
I have trouble with that.
So, Your Honor, as far as what the evidence was, the appellee put into evidence the original child support order, which was prior to 2011. The testimony at trial was that that was an outdated order, that there were subsequent amendments to that order. And that came from Mr. Perry's testimony at trial. It was unrebutted, but that was not the operative agreement. There was nothing put in after that saying what the operative agreement was in 2011 forward. The unrebutted testimony was that as of 2011, Mr. Perry believed he had fully settled all of his child support obligations. And from 2011 to 2017, there was no litigation or dispute between Mr. Perry and his ex-wife. That period of time is when these transfers took place. During a period of time when Mr. Perry had fully resolved his dispute with his ex-wife and before she re-arose with a new issue. So during the period of time, there is nothing here other than the quote unquote bad motive that this court 45 years ago said is insufficient to allow an equitable.
Did he have a lawsuit going on with his former,
He had sued his former employer. And that's the only other creditor, but that's the thing, you can't, what Spoonholtz and Steele say, it is not enough to say somebody generally might be a creditor. You have to actually have proof of a debt. There has to be an actual creditor, not just allegations that somebody is owed money. And that with regard to Horizon, Mr. Perry sued Horizon. He alleged that they owed him $5 million.
but they counterclaimed against
They
him.
did counterclaim against him, but Ms. Turner testified at trial in this case that there was no factual basis for that. And in fact, Horizon ultimately paid Mr. Perry $1 million. You can't say that you have creditors, an ascertainable creditor in the way that this court has qualified these equitable defenses. When you have a very valuable claim against somebody, they happen to raise a counterclaim as part of their defense and they wind up paying you. That's not a creditor. And the only creditor,
affidavit said he didn't have any claims either.
I acknowledge that, and that there was an issue with the affidavit and the accuracy, and Mr. Perry testified.
And back to the evidentiary issue about the child support, I'm just looking at the trial court's order. And I don't know off the top of my head whether the evidentiary circumstances around this testimony were, like whether an objection was made. But the court found that your client testified that he could keep the money attendant to the loan agreement if he won that lawsuit, to keep it away from the ex-wife.
So to continue on what I was saying with regard to the ex-wife, clearly that's the most important thing here. That's what was focused on, even in the closing, the written closing that Ms. Turner submitted. They talk about, in general, this was esteemed to protect it against creditors, which Steele says isn't appropriate. And then they say, in particular, his ex-wife. They hammer below and in their written briefs that his ex-wife was a creditor. But the issue is multifold. One, there was no evidence that she was actually owed money. There was a 2017 claim that arose that wound up being settled, but there was no adjudication whether she was actually owed any money for child support. And importantly, the only evidence that was before the court being this outdated document, but even assuming that the agreement is still reflected in there, the agreement was Mr. Perry would pay 20% over and above $100,000 in income towards child support. What they pointed to was, well, there was a number of years where he generated more than $100,000 in income.
And
The
you're
testimony-
splitting the hairs on whether that's capital gains or some other form of realization.
That was an issue, but
Just getting back to the basics, because we got a lot of rabbit holes to go down here. But back to the basics. He's got a child support order, he's got a minor child, got a history of litigation with this woman, testifies himself that he would, the part of what he was doing was trying to keep it away from his ex-wife. And the trial court finds that they had this arrangement to shield them from creditors, including the ex-wife and Horizon vendors.
Your Honor,
Are you telling us that what we're going to break on here is there's not any evidence to support the trial court's finding? I know you've advocated for substantial confidence.
there is no evidence to support that she was an actual creditor, and part of that
But she don't need to be a creditor until the kids, the age of the children.
part of that is if the issue is 20% over $100,000 in income, him placing his property, his homestead, he's living there in Florida, him placing that property in his name and his girlfriend's name, in both of their names, doesn't affect his child support obligations. It has nothing to do with income.
Well, I mean, you went down these rabbit holes in the meeting as well. Or you don't seriously contend that Florida steals a homestead property from child support obligations,
No.
do you?
No, Your Honor. My point is If the issue is his ex-wife was a creditor, a potential creditor, which we don't agree with, but was a creditor because she might have been owed 20% over his income, he could have put $10 million in a residence here. That has nothing to do with the child support obligations. What matters is his
Counsel, it
income.
seems to me that there's a difference of opinion as to what a creditor is. And it seems to me that what you're saying, a creditor is one who has a claim that's been reduced to a judgment in some way. Okay, whereas another position of a creditor would be, for example, as Judge LaBrite just said, that the ex-wife is going to be owed child support until the children reach the age of majority. So technically, she will be a creditor of even amounts that are not yet due and owing. So I think we have a difference of opinion as to what a creditor actually is. And anyone who engages in asset protection, which is what was clearly going on here, the effort is to protect these assets from really future creditors, potential creditors, because if it's done while there's actual a creditor who's got it reduced to judgment, it's a fraudulent transfer.
And
I don't think the cases say that.
Well, my reading of the cases, Your Honor, is that if somebody engages in asset protection, which is what this was, as Mr. Perry testified at trial, unorthodox, possibly ill-advised, but it's asset protection. And he said this was to protect it in general from any creditor. The only creditors that the appellee could even try to identify, because he owed no debts, he had nobody he owed any debts to, there's no credit card debts, nobody was coming after him, was to say, well, you had a lawsuit with this other company, but that company owed him money. And to say, and you had child support obligations to your ex-wife. But all of these purchases and all of the titling took place during a time when there was no claim or litigation pending.
But there has been a history of child support avoidance.
Yes, Your Honor.
Yeah.
But what Spoonholtz, what I believe Spoonholtz in this court and Steele say is it's not enough to say your motive is to protect it from a possible creditor.
And I understand your client's position because he shook his head when I said what I said, which of course he should not be doing. But his position is he's always paid. I understand that's his position.
Yes, Your Honor. And that was his position. And there was no evidence to the contrary at trial. There was argument, but there was no evidence that at the time of trial or at the time of these transfers that he owed anything.
Let's stay focused on the one point. Do you disagree that his former wife would be a creditor from until the child reaches age of majority and to the extent there's amounts due from that time? Whatever the statute?
I think there are potential creditor. I think it is.
Potential, actually.
I think if there's a child support obligation, then they are a creditor. But that being said, the evidence that there was no evidence put in that he didn't meet that obligation. There was argument. And the court did not make a finding that he.
There was an order that may have been outdated, but it evidenced the fact that he has a child support obligation to a child that was then a minor.
Yes.
And if I'm not mistaken, the child either has or is about to reach the age of majority right about now.
I believe you may be correct, but I don't recall.
So at all times, material between whenever this relationship started, 2007 until 2019, she was at least a creditor in the sense of an ongoing obligation.
If we to move, even though I don't believe that she qualifies, for the sake of argument, if we assume she is a creditor, you still have to show that the titling these properties actually hindered or delayed her ability to collect or to recover. And the issue that was raised below.
Where does it say that?
I believe that what Spoonholtz says is that you have to have more than just an allegation or a possible creditor. What Spoonholtz, what the Supreme Court says is there has to be showing in the evidence that the judgment creditor was in any way delayed or frustrated. And here, there was no evidence that the ex-wife was delayed or frustrated. In fact, what the evidence was is that Mr. Perry filed his tax return that showed his income that was in dispute. So his ex could have gotten those tax returns. She didn't file a suit saying you owe me back child support and then couldn't collect it in Florida. If that was the case, we'd have a very different case here. But the issue is there was no showing that the ex-wife couldn't discover his income, because that's what I'm trying to emphasize. It wasn't his assets that mattered, child support, it was income. Him having his home titled in someone else's name didn't affect his income. So it couldn't have impacted his ex-wife's ability to collect child support. Having these rental properties that he didn't generate income on titled in someone else's name doesn't hinder her ability to collect child support. Is there possible under the case law saying, the motives are questionable, where when both parties, they both agreed to this. It wasn't Mr. Perry doing this on his own. Mr. Perry and Ms. Turner decided to do this together. And as a result of something they both decided to do, she winds up with a complete windfall. And that's in what we believe is that the equitable defenses, and what the courts say is you can't apply an equitable defense to allow a defendant to get a windfall. And that's almost exactly, our case is almost exactly what happened in Steele. You had
No, your case is not.
You're at 15 minutes, just so you know, it's your time, use it any way you want.
And you can come back after that on this. Steele was a dismissal. And you're procedurally distinct.
I will, let me address that and then I'll read whatever time is left over here. Correct. Procedurally, we are distinct. But what happened in Steele is this court sent
And
it back.
there was no, the affirmative defense in Steele, the way that case was played is completely distinguishable, but I don't know.
Thank you.
You're gonna have 4.5 minutes when you come back.
Thank you.
Morning, may it please the court. John Bagan for the appellees, Donna Turner, and DNR Space is also for the cross appellant Donna Turner. May it please the court. I think it's really important that we not get lost in the weeds, and I think obviously the court is well aware of the issues here. And to break it down in a very simple sense, I think the best example of not getting lost in the weeds is, all right, what was Danette Perry to Richard Perry? The next wife seeking child support. Now, the appellant wants to make the argument that, well, she's not a creditor because there was no child support owed. There was absolutely child support owed because Richard Perry at trial testified that he made all of his child support payments based on his $100,000 salary. He's very proud to admit that. It came out that from 2010 through 2014, he made substantially more than $100,000. There is no question. We're talking about who's a creditor. Danette Perry is absolutely a creditor. She's a
Well, long story short, he eventually settled all that just before the trial, correct?
He settled that on the basis of what Danette Perry knew about his actual income. I have no idea, but
Can I sort of get you to the chase on the question I have about your side of this? My understanding of inferior delicto is that it's a subset of the unclean hands defense. And with respect to the unclean hands defense, your opponent has argued that I can't think it straight, Donna, and I go
Ms. Turner, yeah.
disrespectfully, that Donna was required to prove not only the, sort of the misconduct component, but also reliance and harm on the conduct. And help me out with that, because I think what you argued in your briefs was she relied on the setup basically as part of almost what it seems like an employment relationship. She's working for him as sort of the property manager on these rental properties. And certainly the harm, and I think this is what you argued in the brief, was here we are. Talk to me a little bit about that, because I don't think you have much precedential support for those specific points.
well, I think if the briefs characterize my client as like a property manager, that's not what was intended. She was the owner of these properties through her company, DNR Spaces. But regardless of that fact, I don't see the cases that cite the need for reliance or harm on the person raising that defense. So the cases cited by the appellant are foreclosure cases that state, well, if you're going to claim this unclean hands, you need to show that it's some way affected you.
Right, if I lie to the bank about my income, and
Right.
owes me money,
Fill out
and
an
I'm not gonna
application.
have that clean hands argument against the bank.
Right, and so I don't see any cases that deal with our factual scenario, which is concealing assets in pari delicto, that requires some type of harm on the part of the person that played a role in it, the other person, the defendant, for example. I don't see that precedent in the court cases. Basically, it's, you know, the defendant's position is stronger when they're two equally at fault, which in this case, you can make the argument that Mr. Perry was far more at fault for this scheme and defrauding creditors than my client was. But certainly you would need at least 50-50. I think we're over that 50-50 mark. And once you hit that, the defendant cannot raise any claim. The defendant, you know, leaves the court. The court's not going to reward the defendant for this in pari delicto, this unclean hands. And so I don't think you actually need that reliance or the actual, more importantly, the injury or the harm from the defendant who is raising the defense. And that's how I would characterize that. I just don't see the precedent there that requires it. There's certainly a host of cases out there that hold that someone who's doing something like this, something that Mr. Perry did for all of these years, cannot come to the court with clean hands. And the court's not going to tie a bow on Mr. Perry's scheme to keep money away from his ex-wife for the benefit of his minor child. So that's what the court cases bear out. And I just don't see the injury aspect of that. I certainly see it in the foreclosure cases, but I don't see it anywhere in the body of case law that should dictate this case.
Put it in a nutshell, your position is that the requirements to carry the burden to prove the defense, as articulated in the foreclosure cases, are distinct from proving the defense in the context of dealing with a third-party creditor.
That's correct, Your Honor. I think they're just completely different factual scenarios.
Can we talk a little bit about the loan agreement?
Please, yes, Your Honor.
Yeah, because I think that's your client's cause of action.
It is.
And obviously there are some weird things about the loan agreement, not only the fact that it is very cryptic and short to the point, and obviously not drafted by a lawyer, at least it didn't look like it. But there was concerns about the misrepresentations in the loan agreement, and the trial court basically rescinded the loan agreement because it felt that it was fraudulently induced, or at least Mr. Perry was fraudulently induced to sign it. It misrepresented the amounts due in it. It's kind of hard to find fault with what the trial court found, because your client was attributed to being the drafter. It represented an amount that was far and above the attorney's fees it was supposed to represent, and included a lot of her expenses and fees and things of that nature. And he trusted her and signed it, you know, because there were a couple at that time. So there's a lot of problems with it. It's hard to find fault with what the trial court did. So tell me your view of this.
Well, our contention, Your Honor, is that there were two misrepresentations found by the trial court. We're not disputing that. The question is, can you rely on the second one? So the first one is about the amounts. The first one, the court found that the amounts that were stated in the loan agreement were not correct. They were supposed to be for only Mr. Perry's attorney's fees.
188,000, right?
Right.
Opposed to 355.
355, yes, a large number. Mr. Perry admitted the number was 188. So the court found that this amount was misrepresented. And we don't have any contention with that. We certainly understand that the court found that. Now, the question is, what about the second misrepresentation? The second one the court finds is, well, really in the end, I know the amounts were wrong, but in the end, this was never really intended to be collected anyways, because it was part of this fraudulent scheme. Now, my contention is, following the trial court's case that it cited, which is the Padilla case, is when you have a misrepresentation that, hey, Mr. Perry, this is
Can
not.
you really blame the trial court for the ultimate decision in this case?
I can blame it for the.
People misrepresent everything on both sides of this. There's more shenanigans going on in this relationship and these deals than you can shake a stick at. And the trial court basically said they're both wrongdoers. I'm just, you know, I'm not ruling for either one of them. I mean, can you, honestly, as a human, can you find fault with that?
I can, Your Honor, and just, and it's on a small point, is that this is a one-page loan agreement under basically trying to collect a breach of contract action. And so, yes, you have a lot of different factual scenarios around this relationship, but if you break it down and you look at this one sheet of paper and you say this, by law, it's signed by everyone, there's no real defenses that were brought other than the fraud count. There's no incapacity, there's no duress. This is something that someone, when they sign that sheet of paper, should be able to live up to. And if that's the area of law that we're dealing with, I believe our defense and that this misrepresentation cannot be reasonably relied upon. And that's, well, you know, I'm never going to collect this from you, just sign this. Well, the agreement that you actually sign is says the exact opposite of that. And there's good case law that states that you can't rely on a
But
representation.
the trial court's finding was that neither of them intended for agreement.
And there's not a merger clause in it either.
There's no merger clause. I don't think that's dispositive. I don't think the Padilla case states that that's dispositive of whether someone can rely on a misrepresentation stated before the agreement signed. And so, yes, ideally you'd want the merger clause language in there, but I don't think it means that you can rely on something, on a misrepresentation that states the exact opposite of what the agreement states that you signed. And so that's where I think the issue is, and don't contest the amounts that were misconstrued. It's the reliance on, well, I'm never going to collect this. The agreement says the exact opposite. So if we're going to award any amounts under this loan agreement, if it means anything at all, then Mr. Perry should have to pay back what he admitted and what his expert admitted at trial that he owed, which was $188,000. And so that should be the true amount. So if we're looking at fraud, if Miss Turner,
This is what I was asking about. What the trial court found was, and this is the finding, the parties never intended the money used for defense attorneys to pay. And no further action or order of the court is required to undo the transaction. So he's just leaving them where found them based on that finding. And I'm having trouble buying into your sort of two-step.
right, well, I think initially you have the rescission. I think the court cites these cases for a reason. The court cites the cases I cited for a reason. It states, well, you can't rely on that representation that I never intended to collect the money back. But there's this fraudulent misrepresentation about the amounts. And so I'm going to grant rescission based on the amounts. But the rescission, in granting the rescission, you have to restore the parties to their position. And in order to do now that the court in coming to the conclusion that nothing needs to be done in order to restore the parties, is that the parties never intended to actually collect on this. And that's where I take the issue with, if we're going to restore the parties, if we're going to give the true amount that should be owed under the agreement, it'd be the 188, because there's no question, it was admitted at the trial, but it's not like there's a dispute as to what Ms. Turner paid.
And the problem in putting this agreement in context with the bigger picture is there were all sorts of agreements and things done that nobody intended to be what they look like.
Right, I just think we have a written agreement, though. I don't think that all of a sudden we need to exclude a duly signed agreement, and just.
A lot of duly signed things here that weren't, and you're capitalizing on some of them, for example.
And the gifts that weren't gifts.
But, I mean, you can't have it both ways. The affidavit is the cornerstone of a big part of your argument, because it didn't mean what it said, right? It was based on a falsehood. The counter to that is this loan agreement didn't mean what it said. It was based on a falsehood. That's endemic to this relationship. Nothing that they wrote down meant what it said.
Well, I think just because you have this relationship, that any agreement that they actually enter into that's actually signed, of course, going back, if
Your
parties.
client's the beneficiary, but it doesn't sign deeds, title to properties that are in her name only, that he says that's not what we meant to do. So it's troublesome to pick out the one and say, well, all the others that didn't mean what they said, they, that weren't true statements in writing, but this one's true.
We really meant this.
Well, I think the other agreements were, if there was any, I don't think there was any solid agreement that the court found, but this one's not.
The impact of writing something down and affirming what it means, and, in a sea of written documents that everybody now says they didn't mean that, this one is special, and it does mean what they said, that's kind of hard to.
And another way to put that is, we were lying then, but we're not lying now.
Sure, but I think it doesn't mean we just throw out any type of agreement that these two enter into. I don't think that the court is
Well, I mean,
allowed.
what the trial judge did was exactly that, and just say, these people were engaged in all the shenanigans, and I'm gonna leave them where they found them, under these doctrines and specific to this loan agreement, in the context of this. They're both lying to each other, where you don't have to repay it, yes, you do, I don't know. The amount in here doesn't mean that's not what we agreed to, and just tough to stomach the idea that this one thing is going to be a beacon of
Well, I think it's-
clarity and enforceability against the backdrop of this is all a show game.
And the problem is, at the trial court, no doubt was fully within its rights to say, neither of these parties have any credibility whatsoever. I don't believe anything they say about anything. Don't you think that'd be fair for the trial court to come to that conclusion?
I think the trial court did come to that conclusion. I think the difference is we're dealing with equitable claims brought by Mr. Perry and then a legal claim brought by Ms. Turner that states, I have a simple breach of contract. It's a one pager. He agreed to pay me back $335, which the court should have cut down to whatever he actually did owe, which he did. And then the court found under a misrepresentation, under fraud.
Well, it's sort of interesting that the way the lawsuit started was with your client's complaint to enforce this agreement, and I think get him out of one of the houses. And the response to that was, oh wait, there's a lot more.
Well, it was initially not the agreement. It was initially just the ejectment action or the unlawful detainer action that started everything. Then the real estate matters got, exploded. And then the loan agreement was actually brought into the case through Mr. Perry stating a declaratory action because Ms. Turner sought to enforce the loan agreement up in the Illinois courts. There could have been a provision in there that venue or jurisdiction provision, it escapes me now, but it was eventually sent down here and then litigated down here because it made sense to bring everything all in one heap. So my client didn't sue on the loan agreement in Florida initially. It was brought in Illinois and then it was brought here. So I think there's a difference here between a legal action under a simple breach of contract and equitable claims dealing with unclean hands and concealing assets and that kind of thing. I think when we start saying that just because these two engaged in this scheme to defraud Mr. Perry's creditors, that all of a sudden any type of legal agreement that they enter into, signed or not, notarized or not, doesn't matter, we're just going to throw it all out. And I don't
They
think that's
also
what the court
engage
did.
in a pattern of defrauding each other.
Sorry.
They also engage in a pattern of defrauding each other, not just their creditors.
Well, I think the court found that. I would agree with that. I think the question is, can the court enforce that misrepresentation when the contract itself states the exact opposite? And that's my argument is that
Well, it's part of the, I mean, it's important, I think, as Chief Judge Morris said a little bit earlier. This agreement was at the part of what I think we can all agree was called by the trial court a scheme. And the fees were arose through the action of the former employer with Verizon, and the can't all these names, but that litigation. And the whole point of a lot of what was going on here was, in the event that there was going to be a judgment or a claim growing out of that, he wanted his assets away from it. I don't think that's contested.
I don't think it's contested either. I think the issue becomes whether you can use that fraudulent misrepresentation, which the court found. I'm not stating that the court was wrong in finding that. The question is, can you reasonably rely? Can Mr. Perry reasonably rely on that when the contract says something else? And so just because you have
He
this,
wasn't equally situated to know these things. I mean, they were his lawyers.
Mr. Perry?
Yeah.
Well, yeah, I think they,
So I mean, we really want to get down into the weeds that we wanted to avoid. We could do a reasonability analysis as to his reliance, and that, I don't think that holds up.
I think if you're relying on something that's completely contradictory to the language of the loan agreement, which is
They're his lawyers.
no, I
He
understand,
knows what he owes them. He's getting the bills every month. They're not sending them to her.
but my client wanted to memorialize that in writing. Obviously, this was later on in the relationship, and she wanted to be paid back for all the that she did.
It's sort of, asks me to suspend credibility to say that he didn't know that 335 had nothing to do with the actual number that was owed to his lawyers, which was like half of that. That doesn't seem reasonable.
Well, he should have known that, but no, I mean, yeah. Well, yeah, I agree that he should have known that, and obviously he didn't contest it at the time. He contested it after he was sued on the loan agreement. But in any event, I mean, the court found that was a part of the misrepresentation. We're not trying to overturn that. The question becomes, for the 188 that he actually does owe under the loan agreement, can you basically eliminate that entire amount under a duly signed contract just because he relied on a misstatement or
I
a
think the
misrepresentation?
answer to that question would be a lot easier if the only thing we were looking at was the loan agreement, and the loan agreement was independent of all the other activity that occurred here.
And I think it should be. I honestly do think that this is legal argument we're making under a breach of contract, I'm not aware of case law that states just because you have,
Well, fraud
other
is
deals.
fact-bound, and this is contextual.
Sorry, so,
Fraud is fact bound, and this is a contextual analysis.
no, it is.
The reasonable reliance on the rest of it.
I just think you can't reasonably rely on something that's contradicted in the words of the contract, and there's case law that states that. And now if we're expanding our view of outside of this contract to just eliminate the contract altogether, I think you kind of get into a slippery slope argument of, well, do we have to look at each person that enters into a contract together, do we have to look at their other dealings? Do we need to look at, you know, the 30,000 foot view of what these people have done elsewhere? And I don't think, I mean, it would be very difficult.
Within the confines of this particular dispute.
Sorry, say that again.
I said it's not really elsewhere, it's within the confines of this particular dispute.
I think so. I think you can draw a smaller circle and say, this is just the contract. Let's look at this contract. And I don't think we need to look at everything else that went on between the parties. I understand the court took everything in, but if we're just looking at a contract that's signed under strict contract law and fraud and trying to undo the contract through fraud, whether reliance on a misrepresentation is reasonable or not.
There's a way of looking at this through the Tipsy Coachman lens that, you know, the trial court found that he didn't know. But the evidence is such that it's hard to believe that he could reasonably rely on such a vastly different number when he was the one that had incurred those fees.
Well, I mean, the amount, again, I'm not disagreeing with, I mean, there was a misrepresentation there and he admitted he owed 188, his expert admitted he owed 188. But the question is the entire loan agreement completely rescinded because the judge frankly didn't believe either or maybe even like either of your own condition? Thank you, Your Honor.
Thank you.
I appreciate your time.
You have 4.5 minutes, so.
Thank you, Your Honor. Just briefly with regard to the loan agreement, what the trial court found primarily was that neither party actually intended for this debt to be paid. And that was a factual finding that nobody intended this debt to be paid. It was supported by competent substantial evidence. The alternative argument was that there was fraudulent inducement which justified rescinding the agreement. Both of those are supported by the record and there's no basis to overturn.
And all these extraneous conversations and parole evidence is legitimate because there's no merger clause here. Is that right?
Correct, Your
Now,
Honor.
you just heard your opposing counsel take a different position to that. So the case law doesn't require that.
I understand that that's their position, but I believe that we've outlined why under the law that the trial court did not err. And there's no argument in the brief assigning a point of error that the trial court somehow considered certain evidence improperly. It's the error is, well, the court should have reformed the contract, not rescinded it, but they don't really identify. I think that the argument that they're trying to expand upon now.
Let's
is
get to the
supported.
part of your case. What's your best case?
So yes, Your Honor, I was about to say, I promise you, I addressed that issue. So there's two things I want to point out. One is O'Halloran to this court in 2007, and that discusses imperi delicto and its origin being illegality. And part of the issue here is
It doesn't say that straight up though.
I acknowledge, Your Honor, imperi
It's a
delicto
dismissal. It's reversing a dismissal.
in O'Halloran.
Mhm.
In imperi delicto is a rarely used defense. It doesn't come up that often. And there are cases that talk about wrongfulness, but as far as I can tell, that the issue has not been decided specifically, that some kind of wrongful conduct other than illegality supports that doctrine. And historically, and that's what this court said, historically, imperi delicto is a defense that arises with illegality. Now, whether this court says you don't need illegality or not, I don't think that question has squarely come up. But historically, it's a rarely used defense that has to do with illegality. I would also point, though, and I wanted to dive a little bit deeper into Steele because you mentioned, Your Honor, that that's a procedurally different case. And I want to address that because Steele doesn't differentiate between unjust enrichment and imperi delicto. It talks about equitable defenses in a factually rather similar case. And that case in Steele was a summary judgment. And what I want to point out is that in Steele, this court cites the Spoonhole. And what the court says is Steele may have been a debtor intending fraud, but there's nothing in this record which admits to a fraudulent transfer. His bad motive may not be in doubt, but, and then going on, it says, but a motive to defraud is not the equivalent of fraud. In this court remanded the
And
case
ultimately,
to trial.
what the court said was there's tribal issues. And the defense of fraudulent conveyance, when properly pled, is gonna center on the gift thing.
And the issue is, this court on a summary judgment said it's not enough, even if we agree that there was a bad motive, that he intended in that case to defraud creditors. It needs to go to trial to determine if the elements of a fraudulent conveyance took place. And this court cites the Spoonholtz. And Spoonholtz came from a trial. And in Spoonholtz, the Florida Supreme Court said you need to establish all of the elements of a fraudulent transfer. That didn't happen here, which is why I believe.
Have you read the Layla case?
I believe so.
You've got limited time, but I want you to know, and it's easy enough to find because it's in the chain of these cases. I think Layla applies squarely here.
Well, Your Honor, I believe that this court has never receded from the view that motive isn't sufficient. And that's what was hammered on at trial, that Mr. Perry intended to defraud creditors. And that was it. There was no evidence that he actually defrauded anyone. There was no evidence that the result
And the
of
affidavit isn't evidence.
the affidavit doesn't show that he defrauded anyone. That's the point, is, as I say, him putting title to his property that he resided in had no impact on his ex-wife, and they never argued it did. They never even said how that could possibly impact his child support obligation.
The other 9 houses.
But again, that goes back to the motive. In the cases where, hey, we can agree that somebody might do something that's wrongful.
Your other time.
Thank you for your time.
Counsel, you both did an excellent job putting the best face possible on the biggest mess I've ever seen in 26 years as a judge. Thank you for your efforts. Thank you.
I'm just used to being out, but we get it, it's fine. No problem. Enjoy.
Our next case is Medeiros versus Medeiros. And it will apply.